It wouldn't be a fun webinar if we didn't have some tech challenges, right, everyone? Okay, so hopefully you are all in the right place. This is the webinar that you were signed up for and seeking to have. Let me address a couple of the admin items. This webinar will be recorded, and those of you who are here and live, you'll get an email with that recording a couple days post the webinar. For everyone else, maybe you're finding it on YouTube. During today's session, you can submit a question through the Q&A button. However, we are not going to be able to hold a Q&A. We really want to be able to have a good, healthy discussion here today. What we'll do is we'll compile those. We will share them with our esteemed panelists here so they get a sense of what the questions and concerns are from companies attending. So thank you again. And also to kick things off, I'm going to do a quick poll while everyone is getting started, and then we're going to have an amazing introduction. So that being said, I'm going to launch our very first poll, which is, what is your organization's biggest privacy challenge today? Is it keeping up with changing regulatory expectations, turning privacy requirements into operational processes, balancing business goals with privacy obligations, or maybe knowing where to prioritize with limited resources? I know you might want to answer all of them, but you only get one. So pick your favorite challenge of the day. Maybe it's what you're feeling right now. And let's share, and then we'll get started with some introductions. I'm going to give everyone just a few more moments. Now we have some people still joining our webinar here today. Post lunch, post coffee, post following meeting. All right, let me share our results. And so we have, the leader is 35% of you feel your biggest challenge is turning privacy requirements into operational processes. That is then followed by keeping up with changing regulatory expectations. And then a little bit lower, but knowing where to prioritize with limited resources. And the good news is many of you are doing well, balancing business goals with privacy obligations. So with that, as I said, I am Jodi Daniels. I am CEO and privacy consultant at Red Clover Advisors. And what we do is actually help companies with the biggest challenge that you have, which is trying to turn these requirements into operational processes. So delighted that you are all here today. To get us started, Kash, can you kick us off? Tell us a little bit about yourself, and then we'll just go down the line, John and Michele.
Absolutely. I'm Kash Chand. I'm the Assistant Attorney General overseeing the Data Privacy and Cybersecurity section of the New Jersey Division of Law, along with a lot of other work that isn't so relevant, so I'll keep that out. We currently, in the Data Privacy and Cybersecurity section, have 12 attorneys, one part-time attorney, two paralegals helping us. So we have a rather big team that helps us enforce the new laws that continue to be passed, along with our NGDPL, which went into full effect on the 1st of this month without requiring a cure letter. And I'm sure a lot of you may have seen New Jersey's data broker registry law, which has been a big topic of conversation, both in and outside of our office. So that's a little bit about me. I just want to flag, and I'm sure this goes for all of the other panelists as well. We have our general disclaimer. The comments and statements that I make are my own opinion and not the opinion of the Attorney General of New Jersey.
Thank you so much, John.
Sure. And so that disclaimer, same for me. I'm sure same for Michele. But I'm John Eakins. I'm a Deputy Attorney General at the Delaware Department of Justice. I head our privacy enforcement team. As a small team, as a small state, probably not surprising that we have a smaller team than Kash's, but a mighty one nonetheless. One of the interesting features of our team and what we're seeing across the country is one of our team members is what we call a technologist, which was sort of a position that was initially spearheaded really at the federal level and has been adopted in the state level. So our technologist has a PhD in computer science and really helps us understand our investigations and data practices in depth, both from an investigation side and from sort of a data analysis side. Our Delaware law went into effect back in the beginning of 2025. And we are currently looking to amend the statute. We have a series of amendments for the law that have passed the legislature and are awaiting the governor's signature. So with that, I'll pass it to Michele.
Hey, thank you. And thank you for having me. My name is Michele Lucan. I am the chief of the privacy and data security section here at the Connecticut Attorney General's office. I've been with my office now for over 17 years. I started in our consumer protection section and then moved over to privacy when we formed a standalone unit back in 2015. We were the first office in the country to create a dedicated unit with folks devoted to privacy work. And because of that, even though Connecticut is also a small state, we have been able to take a lead role on many of our more noteworthy breach investigations and settlements, and also our cases involving consumer data privacy. So that brings me to the passage of our comprehensive consumer data privacy law. We call it the CTDPA. That passed 3 years ago now. So we are 3 years into our enforcement efforts in Connecticut. We've now issued 3 separate public enforcement reports talking about our work over these past 3 years, what our priorities are, what are we seeing. I loved the survey question about the biggest challenge being folks' efforts to turn privacy requirements into operational processes. I think this is something we are absolutely seeing on our end as well. And I know we will be talking about more today. And then last but not least, I'll explain Connecticut's team quickly. So when I started, there were just 2 of us on the privacy team. We've grown significantly over the past few years. We now have 6 attorneys devoted to privacy. We have a legal investigator that helps us do more proactive investigations and enforcement, paralegal, and our team is no doubt continuing to grow. We passed a bunch of privacy related bills this year, and we absolutely need more resources to be able to meaningfully enforce those laws. So this team is going to get even bigger, and I'm excited about that and looking forward to talking more about our work today.
Amazing. Well, we are so delighted that you are here. And just for everyone's knowledge, I have one little slide that's just going to talk about our agenda items here, and then I'm making this going away. So the idea that I had is many of us are fortunate to be able to go to various conferences, and we have a lovely fireside chat. Okay, so maybe it's summertime. I hope everyone here has a cool drink, but we all see each other's faces. What are we going to be talking about? What can you anticipate? Current enforcement priorities. We're going to have, how are you evaluating? We have 3 different states here, potentially 3 different situations. How does that actually work? A favorite topic of so many companies is targeted advertising and selling and sharing, and then children's data. I don't think I can now have a conversation. It feels like for years it was AI. Now I feel like it's children's data. So with that being said, I am going to stop our beautiful screen share and kind of dive on in. So each of you, I'm so glad that you were able to share a little bit about your office setup. What I'd love now is, can you share a little bit about when you're talking and evaluating a company's compliance program? And Michele, you kind of alluded to this a little bit with where those operational processes are you can see that there's kind of a struggle. What are you looking for to be able to see that they're making a good faith effort? Michele, let's start with you.
That is a great question. And so I can say for Connecticut, what we want to see is that a company took our laws seriously and took proactive efforts to comply. So when we reach out, our information requests can be very broad. Where even if we're reaching out because a specific issue came up, we're often asking broader questions. What does your privacy program look like? Provide us copies of your privacy notices, the changes that have been made over the years. What about your internal privacy policies? What about your data protection assessments? So I think there's a really big difference between companies when they respond to us, where it's clear a company is preparing these things for the first time versus a company that has taken the laws seriously and can show documented efforts that it took to bring itself into compliance. So there, these really, I think the responses that we get really run the gamut. And what we want to see is that companies have done their homework and that they can respond to our inquiries quickly because everything is set up and ready to go. And I will say one more thing here because we've heard this. I think I can speak for John and Kosh too when I say this, that none of us are looking for perfection either. So I think that is a misconception that we've heard before, is like some nerves to hand over information because if there are any little mistakes in there, um, companies think this is going to be something that ends up working against them. And I think we speak very regularly amongst the states, and what we want to see is good faith steps towards compliance. And so long as those documents are there and they're provided promptly, it's completely different than an organization that really is just sat on its hands and it's not ready.
Kosh or John, what might you add to that?
Yeah, I would just add on to that. I think Michele brought up a really important point, as you are thinking about this inside your companies. What is important for us, we will talk to your counsel and we will hear their representations about what your business does and what their data practices are. But it is absolutely critical that we have, those documents from made contemporaneously when decisions were made that actually show that's what the business was doing. So really making sure that when those decisions are made, that they are recorded. These are some of the first things that your counsel should be handing over to us when we send something like an inquiry letter.
And just to add on that, we're trying to determine why certain decisions were made at the end of the day, right? Why did you go a certain path rather than the other? And that other path may have impacted consumers. So we want to understand why. If there's a good reason for that, that makes sense. And that comes from the documentation that is supplied. But if you have nothing showing that you have policies, that you've been trying to go back and evaluate those policies after changes in in the way the company is handling data, I think that's important. The documentation, is good, but the documentation should show that you're reevaluating over time how to better comply and how to better protect your consumers.
Kosh, let's stick with you for just a moment. Thinking about the various conversations you've had with companies, is there a theme that you're seeing? Are there trends of investigations or maybe letters of inquiry that you can talk a little bit about? And that might be driving some of the enforcement priorities.
So I think in terms of how companies are reacting to our CIDs, our subpoenas, I think there have been some more less, I would say, cooperative measures being taken nowadays. I think more companies are less transparent about what has actually occurred on their systems, and that has been proving to make our investigations a bit more longer in the tooth, as well as a little bit more contentious, and that I'm seeing as a bigger problem because we're not able to, from the regulator side, look at an issue, get the documentation, and decide, oh, this was not a big deal. This was something that they made every effort to protect their systems, and there was an issue. That issue we don't think is anything that would rise to liability under the Consumer Fraud Act for New Jersey or the other acts. But I do think that there is more of a contentious relationship with counsel where they don't want to provide that basic information, and we're getting to the point where we have to dig more enforcement actions are being moved forward by offices. I think that's impacting sort of the lay of the land these days. And so I just don't find that relationship with outside counsel as fruitful because we are stymied in our ability to figure out whether to drop a case or not. And we have limited resources. And, we have, I would say, good enough, a lot of resources, but they're limited no matter where you go. And so the problem is that we can't figure out what cases to drop, so we have to keep moving on all of the cases. And so that is, something that's going to raise legal costs, and it's just not productive for either side.
Michele, I see you nodding your head a lot. What would you like to offer?
I can't help it because, and I think we all see it. Like there's just a good way to handle these inquiries, and then there's the opposite. And it is unfortunate when companies take the path of making us pull teeth to get information, providing very vague answers, sometimes one sentence answers. And something we always say is that we're just trying to do our best. We're trying to do our best to figure out where do we need to focus our efforts. And those types of methods are obstructive to that. And they really can drag an investigation out that we otherwise wouldn't need to drag out. Like we do have to be judicious about our resources, and we are experienced. We know which cases to pursue. We know which cases we can close, and sometimes it's frustrating when we see these efforts that are really just preventing us from getting the full picture of what happened. We need that to be able to close a matter. We don't close everything. Sometimes there's a legitimate issue. We need to pursue it, but we will not walk away from a case without a clear story of what happened. So we would get to that point anyway.
I'll just add to that. We have, though I said we had limited resources, we have the resources to continue on an investigation. Even if a deputy leaves or I leave, we have structured it so that whoever fills those shoes will keep marching down that same path. So I once had an outside counsel tell me, "Why do you care about this? You're not going to be here in 3 years when this is resolved." 7 years later, I'm still here. So.
You know, several of you have already alluded to how much you all coordinate. And I want to tell you, when we had a prep call, it was so much fun. There was so many laughs and smiles and giggles. This group, when everyone listening, when they say they coordinate and talk all the time, they really, really mean it. And John, I was thinking maybe you could help share a little bit more about what does that collaboration look like amongst, obviously, we have just a short selection of the many states that now have privacy laws here.
Sure. So I think for, I'm not sure the folks that are joining this webinar, but one of the important things is attorney generals have historically cooperated with each other, and you can see it going back certainly decades. In terms of sort of in our privacy area, there are some very structured and formal organizations that help us coordinate amongst each other and make sure that when we have coordinated or joint investigations, that they're all protected by common interest and things like that. So it's important, and we meet on, we're talking with each other on a weekly basis, and we're from the point of every point of an investigation, from the beginning of an investigation. We say, we saw this concerning conduct. Does anyone else have concerns about this conduct? Is it something we want to look at? And that's, in many cases, how a case gets started. On the staff level, we have, a large meeting, and that's how states can get joined up. Attorneys general also talk to each other, and we will also get sort of top-down instructions that, this is an area for that particular attorney general, an area of concern. So there's a lot of ways for us to coordinate, and it's important for us to coordinate because as a small state, I'm sure I would love to be able to go out and just litigate, with every company. That's not going to happen, right? I need to work with other states, and we need to have a lot of similarities in our laws in order to be able to do that effectively. So when we start to talking about coordination, we're talking about both coordination of a case, but really on a policy level. So we're talking about that too.
Michele, Akash, anything you'd like to share as well?
Yeah, I mean, I always joke that we talk to our privacy colleagues more than we would colleagues in our own office, someone who's down the hall from me, I'll talk to John and Kosh more than that person, because this is an area that really does require that type of collaboration. Privacy issues don't stop at state borders. No state can do it alone. There is so much work to go around, and really there's such a strength in us being able to use each other as resources. To give an example of that, John has a technologist on his team. Connecticut will be looking for one soon, but we don't yet. But I wouldn't hesitate to reach out to John and his team for help with an issue if I needed it. So it's really just about it's pooling resources, but also realizing we've got a great group in the privacy realm. It is a wonderful team, excellent attorneys. I'm proud to be part of this group, and it would be silly for us to not take advantage of that. There's also a real benefit to the companies that we're investigating when a multi-state action forms. So when there's a group coming together and saying, let's do this together, because we do a lot of work on our ends to streamline priorities, streamline information requests. There's internal negotiations in addition to the external negotiations. There's a lot of work behind the scenes that I think folks aren't privy to, but it's really us doing our best to say, let's make sure this is as productive as possible, even though there's many states that are interested in this. And even though Connecticut's a small state, we do a lot of multi-state work. We lead a lot of these cases. We are very focused on trying to make sure these run productively and smoothly. And for the privacy realm, we announced a consortium of privacy regulators. It's a bipartisan group, and it will help us bring all of that coordination to the consumer data privacy space. So that's a pretty cool thing to see.
It is exciting.
Yeah, I'll just say it's a giant think tank, which is great because we do bounce off a lot of ideas off of one another, and it's everyone in the various state office groups, privacy groups that attend these calls. So you get a lot of ideas and you get a lot of thoughts about how to tackle issues or identify issues.
We talked a little bit about technologists in these offices, and some of the actual requirements are really technical. I think some companies think it's low risk, and then what ends up happening is some of these enforcement actions end up being fairly technical. What are some of the examples that you think companies underestimate? You're seeing time and time again. Michele, how about you start us off?
That's a great question. And I guess the first point to make is even for states that don't have technologists, that does not mean they're not technically savvy. We have not only staffed up, but we have made sure to educate ourselves on tools that are out there for us to review compliance. I mean, there's many that we can use. We also have, for Connecticut, we have 3 privacy consultants under contract that we can reach out to. So the work is being done to make sure that we can review these issues fairly and carefully, including the most technical issues. I think something that I see companies underestimate a whole lot is that it's not all that difficult for us to find these violations too. So there, of course, this is a technical area of law. There's also what we call facial violations that are very obvious, very apparent, and that can send us down the road to finding the more technical violations. So let me give an example of that. Privacy notices, this is low-hanging fruit for us. There are important transparency provisions in all of our laws. They're aimed at making sure that our state residents have insight into what companies are doing with their data, that they know their rights and they know how to exercise them. And we're still seeing very deficient privacy notices that don't mention our comprehensive consumer data privacy laws at all, or only mention California's. And we're 3 years in for Connecticut. That is something that would just be inexcusable at this point. And if we see a notice like that, we know there's probably more issues, because if you can't even get the public facing aspect right, there's going to be more issues if we were to look. I'll give another quick example of that is if there's a cookie banner that reeks of deceptive patterns, it's very difficult for a consumer to opt out of the processing of their information for sale or targeted advertising, but very, very easy for them to click accept to it. That is another one of those areas where I would ask myself, why is this company going so far out of its way to try to steer consumers in this direction? What does the rest of their privacy program look like? So those are the things that I think folks underestimate is that sometimes it's these issues that are easy to spot that will lead us down a road towards finding those more technical violations. But let me see if John or Kosh have anything to add there.
Yeah, I'll say I think they underestimate who we are as normal human beings in the world who are using these surfaces just like anyone else. We see what's happening, right? And we will use a website and then see that we've opted out of advertising, but then see that we're getting advertisement on a social media platform or something else. I will, on occasion, mistakenly on my phone opt into providing my information and then go let me change that. I didn't want that to happen. It was my mistake. And then realizing that the way to rectify that is far more complicated than it was for me to actually agree to provide my data. And so we're looking at that, and those are things that would violate our laws, and it's simply because we are just using the same websites. I think that is the bigger concern, is that the companies, and the other one that gets me, and I'll speak to it in a moment, is that a lot of companies or representatives in the privacy group will say to me, "Oh, I didn't know New Jersey had a law." Well, something is foundationally not working for your company if you don't know when laws are coming out, when they're going to impact you, when they're going to take effect. And this was from someone at a reasonably sized company. But yeah, it's it's the lack of understanding that we do a lot of our identification of issues just by our daily usage of various websites. And I think companies underestimate that.
I love that. Regulators are people too, and regulators have lives. It reminds me of when I was a kid and I see my kids. Wait, teachers are people too. They go to stores and grocery stores and Target, and they have a life. It's the same. And in this situation, you're using all those everyday websites and apps and have that firsthand experience.
Yep.
Now, John, I know from when you spoke at our Privacy State of the Union that we hosted in January, you also have some really strong thoughts on privacy notices. So I was hoping you might share what you're wanting to ensure for companies complying with the Delaware privacy law. What should they be remembering?
Yeah, and I think it's important, and Michelle sort of touched on it, but we do see, I mean, man, talk about the biggest red flag is as soon as we bring up a privacy policy, it says last updated in March of 2024. Like you just know there's going to be a bevy of issues out there. But it is in all of the laws, Delaware law, I think basically all of the laws that are following this model, do have a requirement that your privacy notice inform consumers about what their rights are. And we see oftentimes companies either have the wrong list of states or they like to hedge. I particularly do not think that language that is hedging actually complies with the law. So I know there's a lot of states out there, but saying you may have this right does not actually inform a Delaware consumer. Frankly, I think any of the consumers that have those rights, that they actually have that right. It's almost itself, a dark pattern. Well, you may have the right. You have to go research your law and figure out if your state has a law. I wish every Delawarean knew we had the law, but they don't. And the point of the privacy notice is to make plain what those rights are, making sure that they follow up with all of the areas. One thing I just want to add on to what we were talking about too, we talk a lot about websites. Here in Delaware, I'm focused a lot on, other devices that you might be, that don't, aren't always front of mind. I know we always go to websites first, but we do a lot of work in mobile apps. like knowing when you put an SDK into your mobile app, you better know where that data is going because there are major issues that are out there. And we've looked at, other devices around the household or that are used by households. So it's not just, the computer and websites. There's a lot of areas that we look at, and it gives us a lot of work.
I want to shift us into opt-outs. Before I do, that's a pretty complex area. So I have a poll question talking about privacy program complexity. Everyone can get their sip of water, take a break from all your handwriting, of all your notes. So compared to a year ago, privacy compliance at your organization feels, this is fill in the blank, much more complex, somewhat more complex. It's kind of the same. Or maybe there's a few of you who say simpler. And then after this, John, I would love to start with you to kind of piggyback on that privacy right conversation that you just had. So I'm going to close the poll here in just a moment, just a few more people answering. All right. Almost half of you, just under, feel it is a much more complex area. And then we have around 38%, it's just kind of above, and just a very small group of you feel like it's the same or easier. And I think it's only going to get harder. And if your organization, many organizations are starting actually, quite honestly, the budget season, you might want to start thinking about what are the resources you need. You heard today, we have 3 states here. They are building and expanding their resources. They are collaborating. We have 23 signed comprehensive privacy laws. We have kids laws. We have mobile apps. It is not going to, I think if I asked this question next year, many of you would say it is much more complex. So just something to think about. And hopefully this conversation today might be able to help fuel what resources you might need to start thinking about next year to help you with those operational processes. So John, what I wanted to ask you is a little bit of where are the common themes that you're seeing companies fall down on when it comes to opt-outs? And when all of you are looking from an enforcement perspective, what do you want to see?
Sure. So, I mean, I think the biggest issue is, and I think we're still seeing this, I think it is getting better after all of the hard work of specifically California has put into it, is that we just see, and we can have technologists and there's tools out there that you can just see from the front end that your opt-out isn't sending the signal that it's not even doing what it's supposed to be doing, that it's continuing to transmit data as soon as you exercise the opt-out. So really making sure that when you have that type of technology, that you've actually implemented it. I know it can be challenging, but make sure that the people that are implementing it actually know what they're doing. We see difficult areas like that. We're also increasingly, focused. I know, and Michele, I'm sure will talk more about it, but obviously there's Delaware now has the obligation that you recognize the universal opt-out. I'm not sure what we're calling it now. It might be an oops, it might be something else. There's different words that get the idea. I always get confused what word we're using at the time, but making sure not just that the little pop-up that you had for your own area works, but making sure that if there is a universal signal that's going out, that you're honoring that as well.
Yeah, just wanted to echo Johnny's spot on. I think the biggest issue we see is that a company will set up a mechanism for an opt-out and then they're just done with it. And that it can't be what's happening. It can't just be the bare minimum to set up this choice to engage a platform. What matters is whether consumers' choices are actually being honored. And we have absolutely seen a disconnect with that. And like John said, California has done really good work on that. And I think this is something that all of us are paying attention to. So it's very important to test that functionality because we can. And the other 2 things I wanted to say in the opt-out area is just back to what I said before about these cookie banners and deceptive patterns. We want to see symmetry and choice. for those cookie banners. It should be easy for consumers to exercise choices, which brings me to the universal opt-out rights. We call them OOPS provisions in Connecticut. I think that's starting to take the lead. Colorado was saying OOMS for a while. It's just easier to say OOPS and also just a little
It's
more
just
fun.
more fun. Come on,
I
we need some
agree.
fun
I
and
agree.
privacy.
But yeah, this is something we're so focused on because the idea is this should be easy for people, and exercising opt-out rights on an individual basis is not easy. So we have been very focused in Connecticut on these universal opt-out provisions and ensuring compliance with that. We did a joint sweep with California and Colorado last fall, focused on these provisions. And we have a robust team of experts and technologists examining compliance with these laws, and we're prepared to continue that effort. So it was a productive effort last time around. We saw good compliance. We're still reviewing. We're still seeing businesses out of compliance. This is a key area. This is something we're going to continue doing. So just wanted to highlight, as John did, those provisions are so important for all of our laws. And businesses need to be testing whether those signals are being honored across the digital ecosystem.
And I alluded to this a little bit earlier, but I should be able to change my decision if I make a mistake or even if I didn't. And that's been something we've been sort of trying to consider as well in terms of our enforcement going forward. And I will say we've seen a few companies that will, after you make your opt-out decision, give you a banner that essentially says, wait, if you go this route, you're not going to get the best version of our website. And we found that a little bit concerning as well. When you make an opt-out choice, that starts to look more like a dark pattern, even though I wouldn't say it fully falls in that bucket, but it lacks that symmetry that Michele had referenced earlier. And I think that's a big part of it.
We recently did a audit of a variety of mobile apps and websites, and it's interesting, Kosh, that you brought up that once you made your choice, you wanted to be able to change it. In this situation, you couldn't. There was no opportunity to change it ever again. Just gone, poof. So really good point that you're bringing up, and something that you're looking for again, which is really important. So one of the things we have a variety of opt-outs and privacy right choices. There's also this idea of honoring those choices across systems. Michele, you kind of talked about through the ad tech ecosystem and vendors and partners. I know some of the other states have also talked about they might want to see, how did you really evaluate a vendor? Who are these people that you've been sharing information to? So when it comes from the lens of how companies might be honoring those consumer choices across an ecosystem, can someone, maybe Michele, I'll start with you, share a little bit about what are you looking for in a situation like that, since you mentioned the ad tech piece?
Yep. So I think as just from a broad view, these rights follow the consumer. They're consumer rights. They're not device specific. So something that we will want to see is companies carrying those rights throughout their environment. And I think that is something that we have already seen is an issue, but hopefully this helps to hear what our perspective is. And our perspective will always be, it's a consumer's right. It follows the consumer. It should follow wherever they go, so long as they're interacting with your business.
John, what about you? I know, think about when a company is sharing information with vendors and advertising partners and service providers. What is the expectation for a company if they're going to engage in those types of processing?
Yeah, so I think in addition to having the technology both to pick up the opt out or something like that, I think you just generally need to companies just generally need to know when are they sharing personal data with third parties, because so one of the opt outs is that you can't set would be to opt out of the sale. So you really need to have an understanding of when are you actually even sharing information with third parties, because that's really, I think, really the cornerstones of what privacy law is trying to protect against, is to make sure that when what, a company does when it collects and processes information itself, but then B, who it shares to. And so, I know we have a lot of details on what we say about what needs to be done in terms of processors. Um, you also need to consider what are you doing in terms of third parties, people who do not have that processor relationship. And I think historically we've seen that companies, in many circumstances thought that, oh, we only need a data processing agreement if we're dealing with EU data, because that's what specifically requires something when data is shared. But I think increasingly you're going to see, um, you know, states like Delaware. I know California has already emphasized it is the contracting and due diligence obligations when you're transferring data to third parties. Under the original enacted language in the DPDPA, there are certain provisions that do require contracting. In these latest amendments, we're being much more explicit in the circumstances where we think where contracting needs to occur and what the due diligence obligations look like. Because frankly, from my perspective, if we have all of these requirements on either controllers or processors, and then all of a sudden our laws do not become applicable just because you transferred it to a third party, I mean, that's just an absolutely absurd result. So I think, look at us. I think you're going to look at states more often, examine what are transfers of data to third parties and how are they documented.
And I'll say to that point specifically, New Jersey's new data broker registry law now includes the requirement that data collectors, those who are collecting that data and then selling it or sharing it with unrelated third parties such as data brokers, are now required to register in the same registry as data brokers. And a lot of that is in part to address the concern that John and Michele had raised about where the responsibilities go and how they travel. Now, those data collectors, if they are required to register under the law, need to provide a lot of information regarding what opt-outs they allow, how they deal with honoring the choices made by consumers, who they have relationships with. So it really is trying to address that issue of, in the past, having companies sell data to a third party and then washing their hands of what happens next.
And I actually have
And
one more
oh,
thing, Jodi, too,
please go
because
ahead, Michele.
and I think John might have touched on this too, but there's also this trend around making sure that companies are transparent about what they're sharing and with whom. Like Connecticut's law was recently updated to provide Connecticut residents with the right to access a list of specific third parties to whom a controller sells personal data. I think that's a trend that you're going to see. This is what happens. The state adds it. Oregon added it. Connecticut's law was amended to include it. Delaware's, I think, was, but this will be a requirement. The expectation is you're transparent about what you're doing with that data and who you're sharing it with. And then to just back to John's point earlier, these contracts are so important between controllers and processors. We're requesting those. We are reviewing them. We want to make sure those are there, that they're passing along privacy obligations, because again, it's the consumer that matters. And the last thing I just wanted to say is that we will follow that full data chain too in investigating these matters too. We've had multiple matters in Connecticut where we start with a consumer complaint. We reach out to a company involved. They say, oh, okay, we got this data from another company, or there's a data broker involved, and we will send inquiries out to every company that comes up as part of that story.
Let's talk a little bit about profiling. And Michele, I might start with you. This is a hot topic in my childhood home state over there. So, right, profiling, very popular as a part of targeted advertising and data sharing. Can you talk a little bit about how the office is thinking about this and its effect on consumers, and what companies should be mindful of as we're talking about this entire privacy rights process?
Sure. Yep. So this is something we said before, is the best thing that you can do if you want to try to figure out what a regulator is going to do is look at their laws and look at the strengths in their laws. Investigations start many different ways. Sometimes it's consumer complaints. Sometimes it's reports from consumer advocacy groups. Sometimes it's a call from John or Kosh. But another thing that is very important if you're trying to figure out where a state is going to head is look at their laws. What are the nuances? What are the strengths? For Connecticut, we have a law that has really strong protections around profiling, and the law has been amended to make those protections even stronger. So now, under the CTDPA, Connecticut residents have the right to opt out of the processing of their personal data for profiling, which is now defined to mean any automated processing that produces legal or similarly significant effects. So that is a big change from the last time around, because it used to be solely automated decision making. Now it's any. So that's an expanded right. Connecticut residents will also have the right to contest the results of profiling decisions. There's language in our law around that that's definitely worth looking at. And then businesses also have to conduct impact assessments for any of their profiling activities. So for Connecticut, for anyone dealing with Connecticut residents' data, those businesses should be preparing for this now and should be in compliance with those provisions, because that is an area where Connecticut's law is strong.
I would love to talk a little bit about sensitive data and kids, which kids are also really sensitive. So, Kosh, let's talk a little bit about sensitive data. Maybe you can kick us off with what should companies really be paying attention to, and what might be a focus area for your office.
Yeah, so I'll at least say that the data broker registry law essentially amended our comprehensive privacy law to effectively prohibit the sharing of sensitive data for profiling purposes. So that's a really big one, especially when that sensitive data impacts kids. Our office has been at the forefront of trying to address issues that are impacting youth in the country. We are leading on the litigation against Meta in the Northern District of California with three of our other sister states, California, Colorado, and Kentucky. We have brought suit against TikTok. We have brought suit against Discord. And that's all being handled by the data privacy and cybersecurity section. And so when it comes to sensitive data, we are really trying to push laws and enforcement of those laws that are going to protect children, especially in that 13 to 17 age group, which is left out by COPPA. So there are a lot of the NJDPL requires that you have to get opt-in consent if you're going to use 13 to 17-year-old data for profiling or targeted advertising. We have other laws that are being discussed to effectively limit the impact of collection on sensitive data from especially these age groups. So it really is a key issue for us. If we see that children are being impacted by data collectors in a certain way, it's something that is going to raise our eyebrows and is going to make us look a little bit more closely at what's actually happening and how that is impacting children. And we also have to your last question about profiling, we just issued a new law about essentially covering surveillance pricing. And so we are looking at different ways to address how profiling of children or profiling of adults is impacting their day-to-day lives. And there we saw how it could impact, basic payment for groceries. And, that's everything everyone here needs. And so that's very important for us. So anytime sensitive data is involved, we are very, very concerned about how it's being protected.
And I really appreciate that you brought up the age range. And for everyone listening, friendly reminder, New Jersey mentioned 13 to 17. We have other states, it's 13 to 16. You really have to go state by state to understand where your audience is and which laws are going to impact you. Are you national? Are you across certain states? Where is your scope and applicability to be able to make sure that you are adjusting appropriately? Maybe you were only 16. but now we have New Jersey, and you're going to want to make sure that you have for 17. So, Kosh, thank you. John, please share a little bit on our sensitive, our children, and you're welcome to add in the fun of profiling.
Sure. So so part of our amendments also this year are also to ban the sale of sensitive data. So that would, when we're signed, that would bring, so we'd have you could actually connect us. You could actually drive. It's just the 95 corridor. You can go from New Jersey to Delaware to Maryland, and your sensitive data won't be sold. So yeah, so I mean, I think, and I really think the sale of sensitive data, the fact that, these states, our legislatures are, telling us as a matter of policy, we really do not like this. We're putting bans in. I think, in the next legislative session, I would not be surprised if this was a, hot area for additional, additional amendments in other states. So, and as Michele mentioned, yeah, if you want to know what our priority is, our priorities are often what the legislature tells us what our priorities should be. So the fact that they're focused on that. I will give a shout out. So when we passed the law in 2023, ours was the first law that extended that age range to include the 16 and 17-year-olds. So I do think there are now a handful of states that extend that. So you have kids, children, and then teens, and that's sort of how you see it. So I find as these laws keep getting amended, many of the states are, adopting the most fulsome set of protections that are out there. So they are still, while there's new laws, in many ways they're converging as opposed to diverging. And it's going to continue to be an area where we focus on. Also in the amendments, we're extending the types of data that is considered sensitive. And it makes it very clear that almost all healthcare data, whether it is a diagnosis or a status or a condition or anything that goes into that, would be covered now as sensitive data. And we would also be adding that inferences. So we would be explicitly adding that inferences that are made to infer a sensitive data category is itself sensitive data. So this is already present under Colorado regulations. I think this would be the first time it's explicitly put into the law as opposed to the statute, as opposed to just a regulation. But make no mistake, I think most people, certainly on the state side, the state AG side, I think most people think these inferences are already covered. These amendments are really clarifying because we want to make sure that people understand what the full scope is and ensure that it states it in a clear way so that companies will comply with those terms.
What I'd like to do is I would like each of you to think about an actionable tip that someone listening here can take away, an area of focus. That does not mean it's the most important area of focus, but just one action tip. And while you're thinking about that, our very last question is actually really going to tie in. So where do you think your privacy program has received the more attention this year? And think about your vote in light of what we heard here today. Is it congruent? Does it feel like where you've been focusing is makes sense because that was a gap for you? Did you hear something today that you feel, you know what, I need to go address that? That might be our next priority area. So with that being said, we only have just a few minutes. So going to share the results. We're kind of split here. My favorite is 22% of you. You can't pick one. I know it's a very unfair question. It's okay. We'll just assume all of it. AI and emerging privacy requirements. We did not talk about AI and emerging privacy requirements too much here today, but I appreciate that as a focus. Consumer privacy rights and consent. You heard here today, that is a significant focus area. And remember, there is an outward piece. Everyone here has a team of people and they can go and test it. Then you got to work your way inside. Vendor and data sharing practices. You also heard here today, they might ask for that vendor agreement and ask what it is that you're doing about that. So shoring up that area is going to make a lot of sense. And of course, policies, notices, and governance. We also heard about making sure that we have the right representation as it comes to different states that are going to be in scope and applicable for you. Cover that. I do appreciate it as a challenge. We've got 23 different states. So how companies are going to actually handle 23 is it's going to be fun. So with that being said, Michele, if you could, what would you like to leave our audience with today? And I'm going to add an extra plug because you have some really amazing advisories. So if you can remind people where they can go and get those.
Yes. Okay. So we issued 3 enforcement reports. I mentioned this up front. All of them are posted on our office's webpage. So it's the Connecticut Attorney General, and then you just go to the privacy section page, and there's a subpage on that for the CTDPA. So it has our enforcement reports, it has resources for businesses trying to implement and honor global privacy control. There's some outreach forms. What do our amendments do? There's FAQs on that page. So definitely take a look, and please read the enforcement reports and reach out to us if there's anything that's confusing. We'd be happy to chat anytime. I think my biggest thing is just going back to what I said up front too, is just to be ready to, really take these laws seriously, take steps to comply, document those efforts, think about what the narrative would look like if we were to reach out to you because a privacy concern came to light, and just make sure you can show those good faith steps towards compliance.
Thank you. Kash, your turn.
Yeah, so I will say I'll give 2 pieces of information. And one, I know we didn't talk about AI, but I'm sure everyone saw the news about AI now hacking other systems. And so with that, I will just say if you're using AI, you really need to be careful when you take it out of a sandbox environment, because you don't know what's going to happen. But I think generally, this is building off of Michele's point. It, document and then use your platforms, use what you're making available to the public, and make sure you're doing it over time. It shouldn't be a set it and forget it type of situation. You should constantly go back to the well to make sure that it's operating the way that you want it to operate, that your opt-outs are working and are being honored, that your ability to make your decisions are symmetrical between opting in versus opting out. So make sure you're just using your platforms to ensure that it is in compliance with our laws.
And John, final tips.
Sure. So actually sort of bringing it back to the beginning, like what do we want to say? I would say, for all of you, to get out there in front of your senior management and your executive level teams and say these are important issues for our companies, because the state AGs are out there, they are looking at this seriously. I know people get impatient and that it seems like Texas is the only one that ever sues on these things, and California is the only one that announces their penalties. I know it's in the pipeline. There's things coming down, and I think they will help get your senior executives' attention when there are significant penalties that get assessed for privacy violations. So these are a serious issue. It's for your board of directors. It's for your CEO.
Well, John, Michele, and Kash, we are so grateful that you could join us today and share the latest from each of your respective offices and just collaboration. As a reminder to everyone, we heard multiple times there might be an inquiry. And John, to your point, what you hear in the media is not always what's actually happening. So to emphasize what you just shared, what your CEOs and board and leadership needs to know is there is stuff happening behind the scenes that we're all not going to know about because it's not meant to happen that way, but it is happening. So thank you again. Red Clover Advisors has a wealth of information. We have a lot of those practical guides. There's more than 24 of them. You can go to redcloveradvisors.com and grab those. All of these amazing people are on LinkedIn. Follow their content. And we, again, are so grateful for everyone here joining us. John, Kash, and Michele, thank you, thank you, thank you again.
Thank
Amazing, incredible information.
Thank you for having us.
Yes.
Thank you.